Court calls the case of fixing housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing 401k Plan.
Aaron Ward this one way. Erica Ward on behalf of ourselves.
All right. And we have a number of motions.
Yes, we have 3 pending motions, Your Honor. We have landlords MSD, we have tenants motion dismiss, and tenants, I've been calling it the omnibus motion because it's actually 3 motions in one.
Okay. And have you, let's start with this notion of the omnibus. I understand what you're saying. Are you guys going to represent yourselves?
Yes, Your Honor.
All right. You know how to respond to a motion.
I would say best I can, yes or no.
All right. I don't know. Did you file?
File a response.
Pardon?
I did file a response.
To the motion for summer.
Your Honor, we received that response.
Pardon?
We received the response.
Yeah. Okay. Now I see it. It's just got it. Okay. What motion do we want to start with?
Wherever you'd like, Your Honor.
I really don't have a preference. It might be, I guess, if I take them in order of how they were filed, but I mean, whatever. What was your?
I mean, selfishly, I would like to discuss my motion first. I think it takes away a lot of their arguments.
And let's go there.
Oh, that's fine. I agree.
Go. What?
Oh, I just said I agree.
Okay. Go ahead.
Your Honor, we have landlord's motion for summary disposition. I believe the briefing, like the lease language itself, is clear. The lease expressly provides that tenants must pay monthly base rent of $5,500 without any deduction or set off whatsoever. As this court acknowledged at the November 7th hearing, which we attached the transcript as exhibit E, the court correctly stated this lease language is not conditional. Tenants in their response completely ignore that lease language regarding the rent payment. Your Honor, going to the reply, the response, their sole defense is that this is a residential lease. I believe the argument is meritless. I don't like throwing this word around, but I believe it's also frivolous. Tenants admit in their filings, this court and the circuit court, that they're operating a commercial horse farm on the property Willow Ward Equestrian. Tenants don't reside on the property and is a business collecting money from boarders boarding their horses at the farm. I'm going to read paragraph 2 from the circuit court complaint. Erica Ward leases the property to conduct her business, Willow Ward Equestrian LLC, allowed on the property by the lease and Scioto Township regulations as an agricultural/farming use. Erica's business is an equine boarding and training facility. And then it continues. Your Honor, again, at the November 7th hearing, you acknowledged the commercial nature of this lease. It's a 7-year lease term that ends April 30th, 2028. Your Honor, you've read more leases than I have, but I have never seen a 7-year residential lease, personally. Paragraphs 4 and 8B also support that it's a commercial lease. I'd also like to highlight in the circuit court, tenants individually are bringing a business interruption.
Can I just stop it for a moment?
Yeah, yes, sir.
Are you really arguing that this is not a commercial lease?
Yes, I'll be arguing that it's a residential lease and the landlord the entire time acted in harmony with us in residential lease premises.
Okay, but you guys aren't residing there.
We're not, no.
So what human being is residing there on those premises that could make this a residential lease?
The property is a little bit unique. The property includes an apartment with a furnace. Right, let's say observation. When we received the lease from the plaintiff, I mean, Obviously, I'm not.
Let me ask you this. Do you know what a residential lease means?
From the residential lease, I believe the onus of repairs are different. Their tax provisions are different.
Well,
Commercial lease.
customarily, yes. But maybe you need to understand that a residential lease can change, even if, let's say, you're successful in the argument, which quite frankly, I'm having a problem seeing that it's a residential lease. Even if it were a residential lease for a period longer than a year, the parties can change the requirement of who has to repair. So basically, what that would mean is this: even if it's a residential lease for a longer period than a year, the term that you're complaining about wouldn't matter. The term is where the term is. That term could be in a residential lease, provided the residential lease is for longer than a year.
Sure.
Put another way,
Right.
the obligation to repair can be changed if the lease is longer than a year.
We have to be notified that the obligation to repair in the lease was changed.
Pardon?
Would the plaintiff have to notify us that the obligation to repair was changed?
It wouldn't be changed. It's just,
Because Section 6 does state that the landlord should make all necessary repairs and replacements to the property in common areas, including heating, air conditioning, electrical systems.
that's fine. The problem is you can't withhold. I mean, I'll let you make your argument. I just don't think it's going to get you anywhere. But go ahead, counsel.
Your Honor, I would. Oh, I'm sorry. Did you want me to continue?
Yeah, go ahead.
Your Honor, the parties also signed in addition to the lease, a guarantee, a separate guarantee agreement, which also evidences that this case is commercial in nature. Tenants made a good point in the lease, also in our favor, that the lease does not contain the normal plate statutorily required notices to a residential tenant. Again, this evidences that this is not residential in nature. Your Honor, even if they're trying to transform a commercial lease into a residential lease and are, impermissibly subletting or allowing someone to live on the property, that alone is grounds for default and termination of the lease. So if that's what they're arguing, that works in our favor because that is a separate ground for termination. Your Honor, the case law is clear that tenants may not withhold rent for repairs in a commercial context. I've cited these cases many times to you. They're cited in the brief and also attached. The unpublished opinion is also attached to the brief. I would continue that tenants are responsible for the actions of their former counsel in withholding rent. I should highlight, just for the record and any subsequent, proceedings, Ms. Tope did file an affidavit attached to the response, Exhibit 4, that it appears to have just copied and pasted large portions of Mr. Ward's affidavit. It talks about how she signed the lease and how she works at Mr. Ward's employer. So I would just like to highlight that for the court. That was in response to our MSD.
Okay, thank you. Before I have you, who represents you guys in the circuit court matter?
Our attorney, Ms. Tope.
You realize that in these two proceedings, whether the representation is made by you or whether it's being made by your attorney, that you can't make inconsistent representations. You realize you can't do that.
You did not represent this in our other case?
No, that is not here yet. But maybe I shouldn't use the word representation in this. You can't say one thing in one case.
Correct.
And another thing in another case.
Understood.
So I'm to understand, and while you guys may not have said it yourselves, but have said it through an attorney, as I'm to understand and what I see, your attorney, Ms. Tobe, has made the representation in a circuit court matter that this is a commercial property.
That I'm not going to disagree with you.
Okay.
I don't know.
Now,
Not.
Pardon?
I don't know if she's made that.
But okay, folks, this is where the problem comes in with you not being represented by counsel. Because if you're going to, and I'm going to give you one break or as many breaks as I think are appropriate, but if you persist in it, there's going to be problems. Because if the representation has been made that it's commercial property there, and then you're left to argue before me that this is a residential lease, that's going to be a problem. A sanctionable problem. Because I almost have to believe that if you're arguing that, you're arguing that in bad faith. I'll put it another way. If you two were attorneys, and you came and you know in another action that you're making an inconsistent argument, and I'm not saying inconsistent arguments can't happen, but if in one proceeding you're characterizing something one way, and then in another proceeding characterizing it a different way, if there were a single counsel doing that, I would have very little tolerance for that. And I would be sanctioning. Meaning every time that representation is made to me, you're going to either have to pay the court or you may have to pay attorney fees to the other side.
I understand.
Hold on a second. Do you realize that's where you guys may be headed?
Yes, based on your statements, you're a judge. I have no reason to not realize that. Yes. The only way I can realistically do is talk to Ms. Tope and say to verify. She's the attorney who followed her guidance the entire time. But I 100% answer everything.
Folks. She's out of this.
Correct. Yes.
You're now before me arguing this case. I won't be sanctioning her. I will be sanctioning you. Because when it comes out of your mouth, you're stuck.
And your advice is what, Your Honor?
I don't really have advice. Look, folks.
So in this case, Your Honor, my argument, of course, was to comment on the residential aspect of the lease. That's why I'm not going to say
here's where I have to stop you. Because there's been documents filed on your behalf in a different court albeit you're represented by an attorney, they're really your statements, right? Saying something different than the two of you right now are going to say, I anticipate are going to say to me, okay? I'm I'm doing my I don't want to yell at you guys. I don't want to sanction you. I really don't. I can tell you right now that if you had the same attorney was doing that in two different courts and I was aware of that, I rarely lose my mind and go off. Well, I probably do it more than I should. But anyway, I would be going crazy. And I would be holding their feet to the fire and making them explain in detail to me how they can have these inconsistent positions. Because here becomes the problem, folks. If you're making that representation, you're probably doing one of the most serious things that a person should not do to a court. And that is that you're misrepresenting facts to me, or you're just out and out lying to me.
I am doing neither, Your Honor. I did not realize that she represented us in the other court in a commercial matter. First I'd heard, so it never were shown before a judge, and I understand what you're saying, but I did not realize that. I read this statement. I'm not obviously an attorney. I did not see that she had done that. Of course, I would not represent the case two different ways, two different lawsuits, and I'm not an attorney to begin with.
Yeah, but you understand the predicament you're in right now.
Oh, I do. You made a quick
Because if you start that argument, and if you guys want to represent yourselves, I'm going to hold you. I'm going to hold you as accountable as I would an attorney.
Is it possible for us, knowing this, because obviously we don't have an attorney, to get an attorney at this point, or is that not possible?
You can always get an attorney. Sometimes you can walk out in that hallway, throw a stone, and you'll hit one. You can always have an attorney. But I don't know how many times I've adjourned it for. Well, I've adjourned it a number of times. Tried to give you caution about your representation, and then gave you an opportunity for you guys to make your own decision about how you were going to proceed. Well, let me ask you this, just stepping aside from the motion. Why don't you have an attorney?
I believe 100% the whole time. Everything's being.
Pardon?
I couldn't see a possible way we did anything wrong. Of the case we're talking about, of the water heater, of the gas leak, and trying to protect people, I didn't see as possible we did anything wrong. We've done. You have people living in a place, there's a gas leak, I'm just trying to protect them. The hot water heater sits 5 people or someone sleeps. So replacing it in a process been established. We've done this before. We had it fixed, paid, took my out lease. It's the same process. I could not see a scenario where me trying to get something fixed to protect a person from a gas leak was wrong. I couldn't. We done it before where we've taken my out lease to fix other repairs. Like,
Folks,
that's why I didn't get it right.
yeah, but if you're renting that property,
Not renting to anybody.
somebody's just there.
They're there for free. My daughter stayed the night there. My wife stayed the night there. It's morning to stay there. But the hot water tank sits within 5 feet of an observation room, and I could smell gas. And I just wanted it fixed. So dangerous. I don't know. I didn't think I did anything wrong.
Here's what you need to understand. And this is where it gets kind of weird, but just based upon the scenario you've given me, whether you're charging them or not, you would effectively be subletting.
Just friends with the people living there. He's stored his deer head in the place.
I hear you, but if they're not, you can't do both. You can't analogize this to a residential circumstance because you're creating a residential thing and then not claiming that they're really subletters or akin to subletters. I mean, you're going to have a problem, folks. You're going to have a problem. Now, if you truly believe that this is residential, then first of all, I think you're going to have a problem and you're going to subject yourself to sanctions. But if you in your heart and your analysis believe that this is residential premises, then that means somebody on your behalf in circuit court has not told the circuit court the truth.
I see the problem.
And then you're going to be subject to sanctions. And folks, when you filed these documents, or even if they're filed, you realize that you're representing that the information contained in there is true.
Mm-hmm. It is. I do realize that.
And do you realize that if I find that it's not true, what I can do?
Mm-hmm.
I don't think you understand.
No, I don't know what the sanctions would mean. I've tried to do things the right way.
You've risen. What do you want to say?
Your Honor, I was just going to say they already rang the bell by filing this response with both of their affidavits, with Ms. Tope's affidavit. I'm not recalling if one of the other boarders also is averring to whether it's a residential lease. But I'm saying they've already rang the bell on sanctions.
I know.
And the sole defense to our MSD is that it's a residential lease. Whereas in the circuit court, they're also bringing a business tortious interference claim and seeking lost profit damages for their business. So that's where we're at.
Want to say anything else?
No, Your Honors. Obviously, another court following advice of my attorney.
Pardon?
In the other case, obviously following advice of my attorney, I'm not going to say anything that would get myself sanctioned. I just try.
Well, you already have.
Well, I realize that.
That's the problem, folks.
Yep. Any further help with that?
And Mr. Ward, I realize you're speaking. Mr. Ward, is there anything you want to say to me?
I'm comfortable with her representing me.
Do something a little bit unusual. I will rule on this motion today. I'm going to talk to the parties separately, unless there's a strenuous objection from either side.
No.
Any objection? Could you put them into my jury deliberation? We can go off the record.